So nobody took jotted anything down. Eh? Wow. So I want to say acceptance. Do we finish acceptance or we didn't? Remember that we are taking like four stream. Or, I mean the same course. So you need to tell us from Tuesday. We do have a stream for Tuesday, for Wednesday, for Thursday, for Friday. So we are the fourth. So if you don't tell me, then it will be mixed up. I don't know which of the classes, so that I know exactly. Okay, someone said we were about to start acceptance. David, well, well, that means we didn't start. We're about to start acceptance. Okay. So we're looking at elements of valid contracts. We'll discuss an offer. We'll look at the element of valid offer. We'll distinguish offer from invitation to treat. And then, as someone was saying, that we're about to start acceptance. Now, we had in the course of lectures, inform you that an offer is that manifestation of intention which is expressed, you know, by the offeror to the offeree, you know, such that the offeror intend that, once the offeree accepts, then it become binding based on the terms of that offer. So because contract is a manifestation of free will, a manifestation of intention, acceptance also has to be final. In other words, as it has to correspond with the terms of an offer. So you could see there acceptance is a final expression by the offeree that he agrees to the terms of the offer as conveyed to him by the offeror. So, you know, um, we already said that the terms of an offer has to be definite, has to be clear, such that the offeree will know exactly what the offeror have in mind. So acceptance must be final. You must accept the terms of an offer as it is for it to amount to a valid contract. So where you qualify it or where the terms of acceptance did not correspond with the terms of an offer, then of course it is known as invalid type of acceptance. So even as businessmen, you know, it's important to know this because we already brought your attention to the fact that uh, acceptance cannot be clothed with a title going about. So sometimes it's we have a chain of facts or a chain of transactions. So as lawyers, we're supposed to dissect and know where at the point that offer was made, and then you now determine whether there was acceptance or not. Now, but we're saying that where even if the document is written acceptance, you still have to check whether the content of that acceptance correspond with the content of the offer. Very important, because if the content of acceptance does not correspond with the terms of the offer, that is an invalid type of acceptance. So you don't just accept a scenario that, oh, it's an acceptance or even so the fact that a document is tied to acceptance is not sufficient. You still have to check the terms of that acceptance and ensure that it corresponds with the terms of the offer. Otherwise, it will be invalid. And that's why there's a rule of mirror image rule. All of you use mirror. You use mirror in your classes, your cars, in your home. Use mirror. Ladies that are lawyers, if you check their bags now, you have mirror inside. So you see that it's how you appear that you reflect in the mirror. So this rule requires that, look, acceptance must just mirror the terms of an offer, the way it is. So you can't dress, you cannot appear in a mirror separate from how you dress up, right? So that's exactly the point that is we're making here. Because any attempt, any qualification, or any amendment of the terms of an offer will constitute what is called a counter offer. So that takes us to what they call invalid types of acceptance. There's what they call invalid type of acceptance. And if you look at all this type of invalid type of acceptance, you see that in all of them, whether cross offers or counter offers or conditional acceptance, all of those ones, you see that you will see the meeting of minds, because when the offeror makes the offer to the offeree and the offeree accepts, the law will take it that the two minds have come together, what they call consensus and idem. The two minds have come together at that level. And of course, so but once you introduce something new, it means that what you introduce new is not what that person intended, because he didn't express it in that offer. So it becomes so because you introduce something new, it's not left for that other party to either accept what you introduce or not. So one type of invalid type of acceptance that's common is what they call a counter offer. A counter offer, you know, and is defined as or described as any amendment or alteration or change in the terms of an offer. As I said, the acceptance must mirror the terms of offer. But if the offeree now introduce or amend the terms of that offer, or introduce something new, or change the terms of that offer in trying to accept, then that cannot be. It amount to a counter offer. Now, the effect of a counter offer is that it destroys the original offer. That's one thing that you need to know. It destroys the original offer. Uh, and you know, one common example, so somebody that go to markets. You have situation whereby you go to market, you pick an item, and the Igbo man will say, "This item, yes, for sale." I say, "This is the price you want to pay." You say, "Bring 100,000." You say, "No, you will give 50." They say, "No, I won't collect it." Okay, I'll give you. Okay, bring 80,000. You say, "No, you bring 60." You say, "No, bring 75." There's that chain of communication. You are that kind of scenario. Now you could see that because the item was it was displayed. We have already understand or made to understand that when you display item in your shop, those are not in offers; they are invitation to treat. But if a customer pick a particular item, it's the customer that makes an offer. So in this level, the customer has made an offer. The price for this item is 100,000. But instead of paying the price, the customer now introduce something new. He has changed the price by saying, "I will give 50,000 or 60,000." Because in that case, the amount that the customer mentioned did not correspond with the terms of that offer. At that moment, the the whole thing has the whole of that the offer has changed. Now, if the Igbo man also say, "Oh, you know what, bring 95," it means that he also counter the amount that you want to pay. So if you also say, "Oh no, you will not pay 95, you will pay 60," you also counter him. If you say, "No, I will not take 60, I will also bring 80," he has also counter you. So you see that there's this series of counter, parties are negotiating. That what we're saying here is that, look, once you change, instead of accepting and you alter it, the effect of that alteration is that you have destroyed that offer completely. You cannot go back to it because it's dead. It doesn't exist anymore. And so you can't say that, okay, if the man say, okay, you should bring 70,000, and you say, no, you give him 50. That offer for 70,000 has gone. You cannot say, oh, okay, no, I'll go. You can't say you want to go back and pay for that 70,000 again. God has gone. So, assuming you don't accept that's 70,000. You say, "Oh, I'll give you 60 or 65." And the man did not reply you. Instead, he sold that item to somebody. There's no breach of contract because by changing the price from 70 to 65, you have altered it. And the meaning of that is that the offer that had the price of 70,000 has been destroyed. It's no more existing. So there's no between you and that person and the offer. For a new price, there's an offer now. The initial person who was offered now becomes the offeree. And it means that the offer you have made is not accepted because there must be offer and acceptance before a contract comes into existence. So if the party now person now decide to sell that item to another person, it means that by conduct, your offer was not accepted. And so the contract not come into existence between the two of you, as the case may be. So as I was saying, so always have this in mind when you are as businessmen and women, when you are, doing a deal or a transaction, and you keep countering yourself, keep countering yourself, keep countering yourself. Always have it in mind that whatever you counter, once you counter something from someone, that which you countered, if it is an offer, it ceases to exist. So you can't call a person and say, okay, wait, let me go back to the price and the previous price that you mentioned. No, it's too late, right? The person, as far as the law is concerned, the life of that offer, once you utter it, it has come to an end. And of course, you could also see the case of, uh, you know, there's also what they call subject to contract. Usually, in contract for sale of land or interest in land. If you want to lease a property for your shop or for a warehouse or whatever you want to lease a property for, or you want to buy land or deal with land, or case may be, the law requires that such agreement or contract must be in writing. For anything that has to do with land or interest in land, the law requires that there must be agreement in writing, not orally, not by not, you can't so you can't say that you buy land from somebody orally, or you rent a house from somebody orally, or you bought a property from someone by conduct or by oral agreement. No, the law requires that it must be in writing. Whether you are renting, whether you are transferring interest to someone, whatever it is, but once it led to land or interest in land, it has to be in writing. Now you could see that usually when you want to pass title in land, the law requires that you should not rush. You should do what they call due diligence. You check whether the person that want to get that acquire that title from have effective or defective title. And then at the same time, you may be needing money. So what happens is that why parties may be, allowed to check the background, investigate and know the effectiveness of the title of the person selling. It is required, you know, most at times that you name you that agreement that you accepted to go into that relationship. You put a clause on it known as subject to contract. So what I mean is that even though you agree to purchase that property or to transfer the interest in that title to the property, it's still subject to contract. That is, you are still going to write a contract in future whereby you will, you know, you know, sign and execute that relationship. So you could see that what you are saying, I mean, what you agree on, what you accept is also in writing. But this first one, you also put it as subject to contract. It means that there's another contract you're going to enter into. And what I mean is that the one that you sign presently that has subject to contract in it, the effect of that phrase subject to contract is that it to suspend all the rights of the parties until that contract, subsequent contract is entered into and executed. Right. So that is the effect of it. And of course, this is what happened in the case of UBA and Tejimola and Sons. Very interesting case. Can someone Google it and let us share it together? UBA and Tejimola and Sons. Can someone Google it so that let's share it together? Is anyone ready? Is anyone ready? Oh, someone said I've discussed that before. Oh, this class now. It's too quiet. This class is too quiet for me. I asked the question, you are not listening, you are not nobody respond to me. So let me just stop. What's going on here?
We can't hear you, sir.
So you would have mentioned it.
The network is breaking, sir.
So you would have mentioned it. So why do you hear me now? Why do you hear me now? You would have ever go on chat that you can't hear me. If you can't, someone should respond. I'm talking and no one is talking to me as if I'm a ghost. Huh?
It's the network, sir.
But you are hearing me now. So why are you hearing me now? Why is that you are hearing me now? I'm asking about the case of UBA and Tejimula, but someone is saying that I already treated that case, that was everywhere we stopped. But I'm still asking, what exactly will happen in that case? That's what I'm asked. What happened in the case? Yes, Kingsley, Chibos or Council. Tell me, Tope, your hand is up. Can you say something? Let's hear you.
Good evening, sir. So, I may not be
Good
exactly get it word for
evening,
word, but
Council.
I recall that good evening, sir. I recall that in a discussion, I was told that it was a case between like a lease agreement that almost went wrong, or a lease that went wrong. So UBA wanted to lease a property from Tejimola, and after having a lot of discussions, they mentioned some things that they would like to probably be property. And then Tejuma went ahead to fix those things. And then all of a sudden, UBA opted out that they were no longer going to take the property anymore. So I think Tejumola sued for, I think, leading them on also. I can't really remember, Sabo.
For
And
breach of
then
contract. Mm.
yes, breach of contract, something like that. Whereas in the real sense, I don't think there was a signed contract, but I think UBA just had an intention to enter into the contract and all of that. So I think the court ruled in favor, I'm not very sure now, of Tejimola, if I'm not
No,
mistaken.
the code rule. You know that it has a phrase subject to contract. There was, that in that agreement between Tajima had a phrase subject to contract. So the UBA won, the court won, say that look, because the agreement between UBA and Tajima that made Tajima to renovate that assets had a phrase subject to contract. It means that the right of the parties has been suspended. So until that contract, subsequent contract, I mean, is entered into, and since there was no subsequent contract, there was no valid, contractual relationship between the parties to amount to say that there was a breach of, there must be a contract before you say there's a breach. So in other words, the court said that phrase, the effect of that phrase, subject to contract, is that it takes away the right of the party. So you can't sue that someone have violated a right under a contract because there's no contract until that subsequent contract is entered into. So uh, um,
I can't hear you. I don't know what that's.
much Temitope for that insight as a businessman, because this thing will tell me now. Can you hear me now?
Yes, sir.
Yes.
It's breaking.
It's breaking.
Okay. It's network. I don't know. I don't know.
Is
Maybe I should because should I change to another network? I don't know. So just let me know. Once you're not hearing me, just let me know. But I think you can hear me now, yes?
Yes, sir.
Okay. So
Yes, sir.
the point I'm making is that
Yes,
as business persons, there are some things that you have to pay attention to.
Yes, sir.
it's breaking now.
Let me see whether I can change the network.
So your
Let me,
line is breaking.
okay, let me change network. See. change network now. I don't know whether it's better. I don't know. I've changed to another network. I was in the. Hello.
Hello, sir. We can hear you, sir.
Hello, we can hear you now.
Hello, sir. It's better now.
Oh, okay, all
The line
right.
is clear now. We can hear you.
Okay, all right. So I was making a point that um, this some of these things are. I know that you are a student, you want to get good grade, but the most important thing is that you should have this knowledge so that you apply it in practice because you're businessmen and women. Because so when you pick any document that you are to sign or you are negotiating in the course of business, and it has things like all this subject to contract, just have it in mind that you know what, nothing is binding between the two of you at that moment. So make sure that you pursue that contract to the end. That is the subsequent contract is also created, entered into, so that you can have all the rights under that contract intact, and you can always sue if a party breaches that that contract. So that's the point I was making. So you see that even though Tujimola has spent, in fact, the company went and borrowed money to renovate that building. After finishing renovation, UBS said they're not going to take it again. But UBS said we still won, and Tujimola could not, win on ground of breach of contract because that document contained a phrase subject to contract. And the phrase subject to contract may appear anywhere. It can just be somewhere in the middle of the document. It can be at the end. It need not be at the top of the stuff of the document. Even though the courts may be flexible, there are sometimes that the court may even disregard disregard the phrase and still hold parties liable. But at least in the case of Tejimola, the UBA was went away with that, despite the fact that Tejimola spent a lot of money within that building, right? So the issue is that another issue here is for us to take notice whether silence does amount to acceptance. And the case of Faith House versus Binley, can someone also Google this case? Very important case for you to also take note of. Faith House versus Binley. So while lectures are going on, you can Google the case of Faith House and Binley, then also the case of Adams and Linsen on Postal Road. Very important cases that you must know as students of law of contract, as lawyers of law of contract. Let me not put it that way. Not students, lawyers of law of contract. Yes. Has someone seen the case now? Hello? Okay, yes. Barrister Abolaji, yes. Abiodo.
Good evening, sir.
Good week, counsel.
Yes, sir.
Were you in court today? Were you in court today?
No, sir.
I saw someone in the Federal High Court that resembles you. Okay, go on.
I think Pet House versus Bindley case. According to what happened, the court held that the silence does not constitute acceptance to an offer, meaning that
So what happened? What happened to the case? What happened to the
what happened in the case, I think it was I've not read every. It's the summary I just read through. I've not read the whole thing. I've not read the whole what actually happened, but it's just the main point of that I wanted to highlight it and stay and mentioned out. Hello, sir. Hello. Hello.
I don't think he's online again.
Wow.
We can hear you. Maybe
Check our WhatsApp group. I've posted the story behind that case, so it can make you present it better.
Okay, I'm back. This network can be very funny. It didn't lock me out. Yes, Abiola, you were saying something that time before the thing locked me out.
Welcome back, sir. So,
Yes.
so according to the story,
Thank you.
I think
The facts.
wanted to buy a horse from his nephew, and Fet House offered a specific price for the horse and stated that if he didn't buy from his nephew, he would consider the
Good.
horse his. So the nephew now intended to sell the horse to his uncle, but
If you didn't
accidentally,
hear from, him, Abi?
sir? Hello, sir. Hello?
Yes, I'm hearing you. We're together.
Okay, sir. So
Hello, I can hear you.
yes, sir. So he offered the Fet House offered the specific price of the horse and stated that if he didn't hear from his nephew, he would consider the horse his. So the nephew now intended to sell the horse to his uncle, but accidentally instructed his auctioneer so to include it in an upcoming auction, or an auction rather. So the auctioneer mistakenly sold the horse. So Fet House now sued the Bailey for conversion. That is to say, wrongful interference with property. So
Yeah.
that is the background of the story.
Perfect. Well, in fact, I love it's like you were there in that court. You were one of the lawyers that appear in that trial. Because the way you put the facts, so sweet. Everybody say you cannot put it like that too.
Yes, well,
So you see that yeah, no, that's good. That's good. So you see that there was a place that said that, they never wanted to, but forgot to, someone said, look, if I don't hear from you, I will take it like this. He intended to, he had it in mind. Because remember that all this he was saying, it was when the man went to court that was saying, oh, I had it in mind to send it to him, but I forgot. So that's why now raise the question here. Whether silence, does silence amount to acceptance? You know, so we see that. That's why I say that no. In that case, something must manifest, even if we tend to. So these are rules of acceptance. Silence does not just general rule. Silence does not amount to acceptance, except it will be construed as such. You know. So if you read the case of Afolabi, the same thing, where they said, please read, study carefully, and sign the duplicate copy attached, signifying your agreement to all the points as listed above. You know, there was no evidence that the plaintiff ever returned the signed duplicate. So these are things that you have to pay attention to. Afolabi's case, for example, you should sign and return the duplicate. You sign and kept it. You forgot. So it means that once you kept it, there's no manifestation of that intention, because silence, keeping it in your drawer, will not communicate that to the overall. So acceptance must be communicated. That's the fundamental rule of acceptance. But what? It must be what? Communicated. Acceptance, just as an offer, acceptance must be communicated. So where you keep it between you and you did not communicate. Because the party would be, your hand is up.
Okay, good evening, sir.
Regine, your hand is up.
Good evening. Good evening. Can you hear me? Well, I have a couple of questions. I don't know if now is the right time to ask. Hello.
Me? Oh, okay, okay.
Can I
Yes,
ask
yes, I
the
can hear
questions?
you.
Okay, so I said I have some questions to ask, but I
Go
don't know
ahead,
if
go ahead, go ahead. Let's listen to you.
okay, so let me start with this acceptance. I think I've come across cases where acceptance was considered, where silence was considered acceptance. I don't
Yes,
know. Yeah, there are some cases where silence was considered acceptance. So I
yes.
don't know how we can juxtapose both because in this particular case, it was not considered as acceptance, but in some cases, it's being considered as acceptance. So that's the first question. Then the second
It's
question,
usually a question of facts.
okay, so I'm trying
It's
to
usually a
establish.
question of facts and circumstances. Uh,
Your line is breaking. Is it
Sir,
cut
your
to hear
line
you?
is breaking, sir.
Go on, Mary Jane, go on.
Okay,
I,
so
I, I heard number one.
the second one is
Number
like
one,
taking us a bit
yes.
back, but I just want to clarify some things. So while you were explaining, I think still on this acceptance, when you were explaining, no, not on acceptance, when you were explaining the offer and all that, you gave an example of you gave an example, yeah, of someone who display goods, and then someone comes to buy the goods. You said the person displaying the goods is just invitation to treat. The person coming to buy the goods and saying I'll pay this, the person is making an offer. But you now say the person stating I'll pay this is a counter offer to the offer that was made by the person that displayed the goods. So I want to understand, like, the invitation to treat, does it have in itself an offer? The fact that the person has placed price on those items, does it shift it from being an invitation to treat to an offer from the person that displayed the goods? Or I don't know if you understand what I'm trying to establish here, or what I'm trying to clarify, sir.
Yes, I understand. I
So
understand.
let me just explain it better. Someone
No, I
displayed
understand.
this.
I understand you. I
Okay.
understand you.
Okay. So I think that's all for now. Thank you, sir.
Okay. So the first one, the other one, the first one, which if you pay attention, even though I didn't emphasize heavily on it, but I'm saying that as a general rule, silence does not amount to acceptance, except, was where I said except where that silence may be construed as acceptance. So it becomes a question of fact and circumstance. And also, if you one thing about law is that when you start by saying the general rule is, when you start by saying the general rule is, then there's always an exception at the end of the tunnel. You know. So that is for that one. So you when you have those exceptions, you are right in that regard. That's for for number one. And then for the acceptance, for the issue of uh, uh, the, there's a money tag on it. It's still, you can't say that you're making offer to the people because the someone that comes from
Hello, sir. We've not been
I
hearing
will not
you all
know
this while.
exactly which of the item. So there's no that. But when the customer now pick that item for, so you discover that in most instances when you there are sometimes that you pick an item when you go, then you know what, the price has changed. I don't know. I've changed with the network I have. I don't know. So at what point you stop hearing me? So that I'll go back to it. At what point you stop hearing me?
We just started hearing you now, sir.
Wow. Okay. So, but I made mention of the fact that for regarding acceptance, right? Silence, whether silence amounts to acceptance, and I made a point.
So we can't hear you. We can't hear you.
It's a third network. I don't know whether you are hearing me now.
We can now, sir.
We can hear you now, just now.
Yes, just now, sir.
So these lawyers, I don't know what you brought to class today. Network change from one network, two network, three. So I'll have means I have to line up networks to have lectures with you. Eh? Wow. Someone said I've been shut out on the network again. I don't understand. But you can hear me now, is it not so?
Yes, we can, sir.
Yes, we can hear you now, sir.
Okay. So the question that Barrister Mary Jane asked, I said that the first one is that it has both the general rule and exception. And usually, I've told you, I don't know what I told you before, but in law, when you say that, when you begin a sentence by saying that as a general rule, there's always an exception at the end of the day. So there's no. In fact, sometimes you have exceptions to exceptions to exceptions that you were even confused. But that's the beauty of law anyway. So as a general rule, there's silence. Because the fundamental rule of acceptance is that it must be communicated. It must be communicated. That's why, because the law paid less attention on issue of silence because the fundamental rule is that something I have in mind must manifest. It must communicate. Now, so if you say must communicate and you also at the same time insist that you be silent, then there will confliction there. So that's why it's a general rule that local. They must be communicated. So the general rule is saying, look, so silence will not amount to acceptance. That's what the general rule is saying. But then there are exceptions because it's the voluntary something. Contract is voluntary. There, and then of course people's behavior can be construed actions of person can be construed in many ways. So there are instances whereby even though the general rule is saying silence does not amount to acceptance, there are still instances whereby the parties will dispense with that, will disregard that general rule and conclude based on surrounding circumstances that in this particular scenario silence amounts to acceptance. And I gave you an example of supply of imagine that you have you are a supplier of this flour that they use in doing bread or cake or puff or some of these that you do. Now you supply these goods to this flour to someone, to someone, a bakery company, and the company did not respond to you. No response as whether they accept the supply that you made or not. Instead, they use that flour to do bread. You know, they can't turn back and say no. I did. But you see that because they have done something outside of the silence. There's something that they did that strongly suggests that they accepted, because you can't convert that flour back to bread again. Can't convert bread back, grind bread again and get it back to flour again. So you see that by the action of that person, even though there was no communication, you know, it shows that there's acceptance in that regard. So that is just, there are so many exceptions to that effect. And a court also established that there are instances whereby you can construe acceptance as being, and there are cases that lawyers will write to you. Even lawyers, when they write a letter to you, they'll say that, look, that we want to hear from you as lawyers. They will write you a letter and say that they want to hear from you so time. That if they don't hear from you, they will take it that you have accepted, accepted that stuff. So in the courts and those documents and such letters are binding. So that's for that first question. Question number one. Question number two, I was saying that, look, display of goods generally, even if the price tag is on it, it still amounts to invitation to trade. Right? So a customer is the one that will pick that item, that good that has a price on it. So you see that the customer has made the offer by picking the goods that have price on it. On getting to the owner of the counter or the owner of the goods, the owner say, the price has changed. So you see that by saying the price has changed, that's, I give you a new price. That has countered the offer that was made by a customer. Now, if the customer say, okay, let me go back and buy at the first, I mean, if the customer say, no, okay, I'll pay you this, and I'll keep dragging, I'll pay this one, okay, I'll pay this one, keep dragging. Now, that owner of the goods cannot go back to the original price that you keep dragging at, except you are giving that price as a new price. Because once you amend the terms of an offer, that amended offer has gone. It doesn't exist at all in the eyes of law. So you can't say you want to revert back to it again. Right. So that's a scenario that I was talking about there. So even if the price is on it, the what do you call it? It's the customer that makes. But you could just also see that, surprisingly, there are also cases that the court have heard that advertisement will also amount to offers, like in Cali and Carbolic Smoke Company, for example. The advertisement, amounted to an offer because something extra was done, and it was particularly because the owner of the company said, "Look, we have deposited £1,000 with our bankers." That statement was one that said, by making that statement, that advert had moved from just being a general invitation to trade to becoming an offer. Because it creates some level of certainty in the mind of the people that will respond to it, that this person have money here. So it's not just advertising as the case may be. So you should take note of all those things. That's the response for the question that was asked by Mary Jane. Can you hear me?
Yes, sir. Yes, I can hear you. Thank you.
Okay. Now, the other one here is acceptance by post. There are so many what they call, modes of acceptance. And in the mode of acceptance, different modes. There are some that the offer will state the mode that you should be accepted. Someone send a message to you and say that, look, if I accept it, send me a message here, or you send an email and things like that. Okay, or if I accept, tell this person. So there is something whereby you also have to, accept by post. And of course, the locals class school for acceptance by post is the case of Adams versus Lindsay. Who have read this case? Adam and Lindsay. Anybody have Googled it? Let's hear from that person. If we have Googled the hello. No hand is up. Adams versus Lindsay. Has someone Google it? Barrister Lua John Ige of Cancer. You want to say something? Okay, Abolaji Abiodun, senior advocate of Nigeria. Let's hear you.
Good evening once again, sir.
Good
So,
evening.
the case of Adams and Nintsa case, the
Lint,
summary
Lint,
of the Nintsa, the summary of the story is the Nintsa.
the facts, summary of the facts, not story, is facts. This is all it was something that happened. So it's
Okay,
reported
facts. Thanks for
facts.
the correction, sir.
Uh,
So the Nintsa offered to sell a wool to Adams Fair Post. Then the offer letter was incorrectly addressed, causing a delay in delivery. Then Adams posted his acceptance to the same day. To the same day he received the offer. Then by the time the Nintsa received Adams' acceptance, he had already sold the wool to someone else. Then the court ruled that a contract was formed when Adams posted his acceptance, even though Lindsay hadn't received it yet.
Thank you so much. Thank you so much. You know, I like the way you summarize it because at least people will understand this very. So now, you see that two things are an issue here. When you post a letter, the letter is supposed to be delivered to the person whom you will post that letter. So in the case of contract, when you post acceptance, the offeror is the one that made the offer. The offeree will not accept. So the offeree have posted the acceptance. Now, two things. The offeror, when the offeree post the acceptance, the offeror is expected to receive that letter of acceptance. So two things. At what point did the contract come in existence? That is what this Adams and Lisa, the, the, the postal rule is trying to establish. At what point did the contract comes in existence? Is it at the time of posting? And if at the time of posting, it then means that even if the other party are not seeing the overall are not seeing the acceptance, it doesn't matter. Once you post in the proper post office, the contract comes into existence. Even if it takes 1 week or 3 months or 1 year before the overall receive it, or is it until that time that the offer will receive the acceptance? So in Adams and Lacey, which is known as the postal rule, is to the effect that for acceptance by post, the contract comes into existence the moment of posting the letter at the post office. Once you post it, it comes into existence. So even if you're not seeing it, and that's why most businessmen try to avoid this postal rule in their contracts. Because someone has posted a letter, you're not even aware of it. It may even lost on the way. And they're saying that the contract had gone into existence the moment the person had posted it, even though you have not seen it. So most businessmen try to avoid it so that they'll create a scenario whereby they would have seen that acceptance itself. And of course, this also extends to electronic contract or electronic agreement. You know, when you send email to someone, is it the acceptance come in when you send that acceptance by your email or until that person receive it at the other end? You know, this is about electronic contract. In Nigeria, is there yet to have a specific law on this aspect. But in some countries, they adopted the postal rule just the same way that a post office operates. They also use email as the same way as it should be. Other countries also say no until when the other person. So there are different regime regarding electronic acceptance. But of course, if you read the case very well, they both try to justify that the post office agent, that if the parties don't want to use post office, they will remove it from their own contracts. That don't want to post rule to apply, and things like that. That is more convenient, that way. So there's justification for all of those ones. But then there are also a requirement that has to be made. That is, for instance, that letter of posting must properly posted. So, example is if you have someone who is a neighbor that is working at a post office, and you gave me a letter to go and post for you. Is that valid posting? Hello, hello.
We can hear you, sir.
We can
I'm,
hear
I'm
you,
No,
sir.
sir,
ask a
that's
question.
not valid.
It's
Ask
not
a
a
question.
valid positive.
It's not
Yeah,
valid.
It's not
exactly.
valid.
Exactly. So you can't say, "Oh, you're my neighbor. I'm going to office. So take this letter, and go and post for me." No, you can't say that the acceptance took place when you hand over to that staff or post office at home. No, he has to take it there and do proper. Is at the time you do. So if the man forgot it at home, if your neighbor now forgot it at home till after 1 week before he remembers, that means that there's no valid contract. Because until it's posted, and then the address also has to be correct. In the case of Adams and Lindsay, it was the overall that misdirected, wrote a wrong address that did not delay. That's why it delayed reaching the overall. But immediately the overall got it, it posted immediately. But because of the delay that was caused by the overall, it didn't reach back to the over the over. It didn't, acceptance didn't go back to the overall on time. And then I think he sold it on the 7th, and on the 8th he received a letter of this. On the 8th, he received a letter of acceptance from. So as at 7 that he sold the goods, the wool, already the contract had come into existence on the 5th, because it was on the 5th that the letter was posted. So, but it was because of that delay, he didn't get it on the 8th. But on the 7th, having waited, he don't saw it on the 7th, just to receive the letter on the 8th. And of course, the court held in favor of the plaintiff. So these are things that, so if you don't want this to be on you, watch out again as businessmen and women. When you have an agreement and they are trying to rely on postal rule, remove it, because it has to do with negotiations. You can remove it. Nobody can compel you that you must accept. So those are the two elements. Now the third one here is consideration. So when you have offer and acceptance, that cannot be sufficient. Um, that cannot be sufficient. There must be a price, between you and University of Lagos, for instance. The fact that University gave you offer admission and you accepted that offer admission, that is not sufficient for you to get MBA certificate. You have to pay a price. University also paying a price. See me here, I'm struggling. How many that I've used different network this evening simply because I want to fulfill my obligation to SU. At the same time, you also are hooked up here, even though there are some people that are just log in here that are already enjoying themselves. Some are already taking the dinner already. While I'm still here, they're taking that dinner, they just log in and they're playing around just to fulfill all righteousness. We know all those things, right? But the point I'm saying is that you're also paying a price. Your data is being wasted. Time that you would have been able to pay attention to other people, you are not divided, whether to be logging here or be there or not. So for everything you do, the price is paid. Those of you that are into families, husband and wife, you know the price you are paying for the marriage to subsist. Even to go to heaven, you must pay a price. Everything is price. For you to enter, you must work. You know, if for the employers to benefit from your services, they must pay. So everything. So in contract, it creates obligation quadrilateral, but then you must furnish something of value. A price has to be paid. And of course, this in case of Korea and Misa, the code tried to define what is a consideration. Can someone read it out? Can someone read that from the second sentence? The second sentence, read it out. Can someone read it?
Consideration must move from the promisee. Consideration must be of real value in the eyes of the law. White versus Bluet. consideration need not be adequate. Thomas versus Thomas.
The first paragraph. Go to first paragraph, the second sentence. First paragraph, second sentence. That's what.
Okay, consideration consists of some rights, interests, profits, or benefits accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered or undertaken by the other. See Courier versus Misa.
Okay. So, but the point I'm trying to make is that, you should pay attention, is that if you observe, that description or consideration has two ways. So they're saying that it can be right, it can be interest that you acquire, it can be profit or benefit according to one person, or forbearance or detriment or loss or responsibility given, as the case may be. Now, I give you a typical example also, when you are purchasing items in the shop, or you are supplying goods as the case may be, and things like that, or you are a consultant, whichever the earnings, what you earn as a consultant, I mean, in respect of those services, you might have sit down before the person will come for the, um, before the person will come for the services. You would have paid money for researchers. you know you would have taken a responsibility to sit down, right, and discuss with that person, give the person the advice that needs to be given. So you have taken a responsibility. You have suffered in terms of, you now attend to any other thing, simply because you want to provide those services to that person as a consultant, so that the person will pay you. So you see that if you want to buy goods in the shop, the same thing. You are going there with 100 million in your account, or you're going with 500,000 in your account. When you go and you do a shopping, you discover that when you do shopping and you pay, you check your account, the money you have in the bank would have reduced. So you have lost that money. But then you also gain. You have gained by what? You are gained by those items that you take home. So you see that. So that contract was saying that you should always see that the price, the detriment is there. When you say that, what have you paid? What exactly have you furnished to retain those goods? You have furnished the price for those goods. Consultancy, for instance, if someone pays you, if that payment is consideration that is being furnished for getting your services. Employer-employee relationship, the same thing. The employers, they furnish consideration by paying the wages, and that's why they can earn your time. They can say, look, once you resume by 8, you can go on break by 12, you resume back by 1, you stay in the office till 5 p.m. Why should they be getting those benefits from you? Because they have furnished consideration to it, which is what? Which is the wages they are paying. So in contracts, that's why they define that it can be in any form. It can be a detriment, it could be a benefit, it could be a loss, it could be a responsibility or taking. So it's so wide. But then they're saying that is something, a price that is paid, and of course is as we're going to see, it also something of value in the eyes of law. So you must pay a price. As someone said that even in Freetown in South Africa, even in Freetown, there's no free food. You must pay a price for it. And that's why you must move from the promisee. The promisee is as good as offeree, or someone that, because contract is exchange of promises. So if you exchange a promise and the contract is created, you still have to furnish something of value. It must be something of value in the eyes of law, not something of value in the eyes of the parties. So what parties may think that it has value in law may not have value, like affection, love and affection. It's been contended that, look, whether love and affection, um, constitutes, a price for whatever benefit that one can derive from contract. There was also a particular case whereby, there was a contract for reward of someone that could identify the killers of a particular prominent person. So the one woman knew the killers, reported, not because to get the money, but because she wants to go to heaven. So the question was whether that price of that revelation, that by reviewing those criminals, was consideration for getting the reward for the money that they had announced. So anyway, we're saying that, look, That's something of value. It's in the eyes of law, not in the eyes of party. So what a party may thought is has real value may not have value. So it's the law that determines it, whether it has value. And of course, value in this discourse, because this commercial dealing, it has to do with money, monetary value, not moral value. Know that very well. And consideration need not be adequate, but must be what? Sufficient. Need not be adequate, it must be sufficient. So what I mean is that for the subject matter of contract, for instance, the value may be 100 million, 200 million, 500 million. But if you decide to accept 100,000 on it, fine. But the adequacy of it would have been, oh, what's the market value of this subject matter? What if if you provide the services to this person, what could be the market value? So we see that even for you lawyers, for instance, like let me say registration of companies, for instance, during the Obasanjo regime, Alfred Babalola, who has university now, registered a company for federal government and he was paid 1 billion. The federal government paid him 1 billion for registering one company. So the same company that will register one company in Nigeria, other lawyers can collect 300,000. But he was paid 1 billion. So you can see that it's not about saying, okay, that is the price for registering this company is 1 billion. So they pay. No, that's not how it is done. It's about sufficient. So if the value even if it's less, but once it is established that that's what the parties accept, that's fine. That's fine. So just take note of that. Look, consideration need not be be adequate. It may not be the exact value, but it has to be sufficient. That is, once parties accept, that's fine. Also, you could see also that the constraint must not be passed. So whatever you are, furnishing as consideration must be in line with the terms of the contract. So if I've done something in the past, which there was no promise made for you in return, and then subsequently someone promised you to reward you based on what you've done in the past, you can't use the past action to claim consideration for subsequent action that that has no link with the past, things like that. And that's what happened in the case of Kenswa to about Benin Divisional Council, which I expect you to go and look at that. Of course, also consideration must not be illegal, immoral, or contrary to public policy. We had a case whereby there were these armed robbers who went to we see the case subsequently anyway. They had agreement that they will rob banks, they rob a bank, take jewelry, take money, and then they'll come and share it. Right? So that was the agreement. So they agree on the percentage of sharing. So when they went for the robbery, it was successful. They gathered money and they stole money and stole some jewelry. So when they came for sharing, one of them was shortchanged. They didn't give him based on what they agreed. So he went and got a lawyer. The lawyer went and sued the other armed robbers in court, and they asked the court to tell the other armed robbers to give him his own share of the robbery that was committed. Right? I don't know if I judges, what will you do? What will you say? Hello.
You lock all of them up, sir.
Yes, sir.
We are with you, sir.
Yes, so as a judge, what will you do now? Armed robber has come before you, say that
We apprehend
is that the kind of
committee.
people were afraid of going to your court?
Sir, I think based on profession, the lawyer will want to do his job first. Then I think after that, all of them should be locked up.
Wow. This is the judge is like, well, I fear now. Me, I will not go to the postcode again. No. Before you lock both the client and the lawyer together. Of course, if you read the case, that was only what happened in the case. The judge arrested both the criminal and the lawyer himself. All of them were arrested. They didn't come out at that day that they went to court, you know. So by just trying to demonstrate that local consideration. So he was saying that he has paid a price, that the price he has paid for claiming that money was the armed robbery that he participated, that he suffered. You know, you could see that even you go to that definition, when you suffered, or suffered, to get something, that suffering itself is a price, is a consideration that you are furnished for it, all of those things. So they were saying that that price must not be illegal, must not be immoral, as the case may be. What is immoral depends, vary from society to society and culture from culture, right? There's also the rule regarding that is on sufficiency now. The question is whether, you know, for this is important for businessmen and women like you, because somebody has borrowed you money, there's someone has borrowed money, they agree on payment plan, repayment plan, but then the creditor is so desperate that instead of allowing, okay, you borrow money and you want to return this money by installment within 1 year. Now, 2 months into that, the creditor said, "Look, you know what, I need money, so I can't wait for you to wait till the end of the year. Just see whatever you can get for me now, bring it, and I will forget about the balance that's outstanding." So the question is that if you promise someone is owing you money, and you say that the person return it, outside of the time for refunding the money to you, it's returning outside that time, right? If it's return it outside that time. So is the price that is being paid is that, look, he ought to have returned this money in 8 months time, in 1 year time, but you now ask him to refund it now. So you know that you are squeezing me, so that's the price he's paying. Now, but you are saying that by doing it now, you will forget the balance that the person ought to pay, the full balance. So the question is whether that will be valid. Whether after collecting this, whatever the man can squeeze, the person can squeeze and give you can still go back and sue subsequently for the balance. Now, this is what you know the each doctrine of promissory estoppel, talk about here. That as general rule, it cannot. That is, payment of lesser sum of money will not discharge discharge you from the original obligation of paying the full balance. That's what the general rule is saying. But then there are exceptions to it. You have issue of promissory estoppel, accord and satisfaction and composition. When parties readjust their debt, and now promissory estoppel is where a party has made a promise and one party has relied on it. If you want to withdraw that promise, then the other party that rely on it will be harmed, will incur damages. Then the law will stop you. Estoppel is when you are stopped. Promissory is from promise. You have made a promise, someone have relied on your promise, that the law will not stop you from withdrawing that promise. Because if you do that, it will affect the the other party, the case. So always when parties are in contract, this one, as I said, is already there's a contract already existing. You're not making a promise until all of this. So be very careful when you're in contract and you're making promise left and right. Because if you make a promise, someone rely on your promise and to change the position of that person. So assuming, for instance, now you promise the person, look, just find something. I'll forget about the balance. Person has gone to sell something that you wouldn't have sold, or to borrow to come and pay you. Then after that, you want to ask them to pay the balance again. Rely on it, and the person have lied on your promise, and if you change it, it would have affected his position. The law will stop you. So promissory is just promise that you made, and someone has lied on your promise, and you want to withdraw that promise. That if you're allowed to withdraw it, it will affect that person, right? So the law will stop you. That's the meaning of stop. Stop. You are stopped from coming back. Central London properties. It was a high risk case. These are all renters. It was cases of price. You can Google it online. It's a popular case. It's online. About rent of properties, that whether the price that was given party can change location from that, as the case may be, right? So any question on that? And that will move to the fourth element of contract, which is intention to create legal relationship. Any question before I move to the intention to create
Hello,
legal
sir.
relationship?
I have a
Yes,
question.
go ahead.
So he's on that promissory estoppel.
Yeah.
The promise, does it have to be in writing or it can be oral? Which of it?
It can be oral. It can be oral.
It can be oral. What
Yes.
about if the other party denied that he didn't make such promise?
Then you have to prove. If the law is that he who alleged must prove. So if I allege that someone made a promise and you lie on it, you have to prove. If you cannot prove it, then then you cannot stand. So you can prove. There are many ways you can prove oral contract now, either by calling witnesses or bringing other circumstances to show that indeed that promise was made. That's why sometimes when you say that they will ask you, were you the only people that in that place, or were people nearby to hear you? And all those questions they will ask, you know. And then also, if the person deny, okay, if I deny, how come that you received this from this person? Just like that, what would have led to it? So there are sometimes that in the course of interrogation or cross-examination, the person would have contradicted himself, and then you can get what you want from it. So but to prove a fact, to prove a state of offense, a different law entirely. They call it law of evidence. Maybe after law of contract, you can still do law of evidence, or I know you are senior colleagues, you are lawyers, so maybe you can just to brush yourselves. But that falls under law of evidence, how to prove a state of affairs or a fact. So if I'm saying that there was a contract, a promise made, if I say it's a fact, there's a key there is a way that the law have, designed how to prove it, and you can always apply that in proving that fact. That's just. But if you cannot prove it, then you can't get a case in your favor. It's as simple as that. Is that okay?
That's fine. Thank you.
Okay, so we move to the second, the fourth requirement now, which is intention to create legal relations. Now, this is very important for you to know that already we are saying that we talk about issue of silence or manifestation of that acceptance must be communicated, must manifested. So, but it's critical. One important thing is that there's an offer, there's acceptance. Parties have furnished consideration to it, but then the law also requires that there must be intention to create the relationship. Now, that word intention is where the problem comes from. Someone have something, it intended something. How can you know that what goes on in someone's mind? It's not possible. There's no superhuman that can know what goes on in that person's mind except God, right? So even those are Christians, they talk about Christ, but Christ is not a human being, he's God. That's why Christ could know what is in your mind and all of those ones. Those are Christians. So you can see that because it's not possible for human beings, so you can only presume. So in presuming um, intention, a contract are divided into two. There are two types of contracts. Three types of contracts divided here. You have social and domestic agreements, you have commercial agreements, and you have intermediates. That is the ones that fall in between commercial agreement and domestic and social agreement. Now, the law now presumes 1 minute. So, as I said, the intention is divided. So for the first one, that is social and domestic agreement. The presumption is that for all social and domestic agreement, the law did not intend, parties do not intend to create a binding legal relationship. There are many examples. The common one, as you say, baffle and baffle. Anybody can Google it. You can Google marriage and marriage, baffle and baffle, can Google it. But one common example is husband and wife. That's the wife can see that between husband and wife, all the promises made between husband and wife, the law intent that there's no, that's general rule. When they say general rule, it means that there are exceptions. But husband and wife, for example, where the wife is a promise made between a contract entered between husband and wife, when they're living together, husband and wife, the law look at them as just lover people. So all these promises that buy you, take you to London, take you to this and that, buy you this and that. Before in the eyes of law, you can't go and sue your husband because he promised you to give you this. I didn't give. You can't sue your husband as long as you're together as husband and wife. So I know some of you are at home doing these lectures. If you are married there, and they don't start looking at your husband one corner eye. No, don't bring law at home. Just have it in mind that when the partner is promising you, in the eyes of law, nothing is binding. No, it's just love you are playing, right? So what I mean is that, um, on the other hand, your children, for instance, you ask children, go home, go, I will buy you this, buy you do those ones. The same thing, and of course, there are some relationships that are not known at all. All this man to man or woman to man married relationship, all those ones they're not even known to law at all. If you go to section 258 of the Evidence Act, define what is legal relationship that are recognized. So, but there are exceptions. There are exceptions whereby husband and wife or partners can enter into agreement and it's binding. So always know that. And you could see those two cases there, it will tell you, where they had issues, husband and wife, they had issues. In the course of resolving it, the wife said, you know what, I won't come back. I won't accept unless you promise this, do this one. So the man now took a paper from his car, and wrote down that I will do X, Y, Z. It was binding on him when he wanted to sell that property to another person. So even classmates, invitation to come and attend wedding, attend party, you accepted, you not come. Well, that would amount to breach of contract because the person would have prepared for your coming, and you say you come at the end of the wedding or party, as the case may, or birthday party, or all those things. Like, even among you, the agreement that, attend the lectures and let me have notes from you, come and explain to me. All those ones. If you attend lecture and not explain, they can't sue you. Students among themselves keep promising themselves no contracts and because that I say contract can be orally made, can be in writing, and also can be by conduct. So even among you as students, you could just imagine the number of contracts that you enter into and you breach it. They can't sue you. You can't sue among yourself because they are all social agreements, which there's no intention to create a binding legal relationship. But in the commercial setting, commercial is business where you exchange, people come together to, to carry on a common business for purpose of making profit, making money. Commercial setting. Like you are doing masters in business administration. Business is all about making money. So in relationship in that business administration, the law presumes that parties intend to create legal relationships. So, that's general rule because there are exceptions also that even in a commercial setting, there's no intention to create legal relationship. Class governor, please monitor your class. So people are making noise at the background. Okay. So where are we now? Yeah. So a commercial transaction, for instance, so because the masters in business administration is a commercial setting. Once you are in that business setting, anything you are doing there, any agreement or promise you are making, that law presumes that you intend to create legal relationship or business or commercial dealing agreements. But then that's the general rule. There are exceptions that even in commercial setting, there's no intention, like betting agreements. You can see, all this football pool, betting, bet Niger, all this bet Niger, for instance. There's always agreement. There's somewhere in that agreement. I don't know. It's people that bet. Ask them. Some of them just go and be betting, playing that bet Niger every day, without knowing that there's a clause in that agreement that says that the agreement, the contract between you, the person, the bet person, the man betting, and the company itself is in honor only. So when you see agreement that has in honor only, it means that it's just a gentleman agreement. There's no intention to create binding legal relationship. So watch out when you are into signing agreement with any person, and just if anywhere you see that this agreement is in honor only, it means that it's a commercial agreement contract, but well, it's not binding on us. It's just a gentleman understanding. That's why you can claim, you can say that you have played the bet and you won 100 million or 1 billion, and they will choose not to pay you, or they may just give you what they want to give you, but you can't sue them. Unfortunately, not everybody knows some of those things. They just go and be playing bet every day, every day, every day. Then you also have another example is collective agreement, labor union. When the labor have, bargain with the employers and they secure what they call collective agreement. It's a collective agreement is in a commercial setting. Labor law, labor practice is a commercial setting. The collective agreement per se is not binding. It's not binding until it's integrated into condition of service. That's when it becomes binding. So you see that even the minimum wage that federal government will, when federal government, agree with union, uh, on salary increase, they still have to go and enact a law. So that agreement between federal government and union itself cannot be enforceable until federal government has to go and enact a law to make that possible. That was when it became so. Even in the private sector, collective agreement not binding until the employers will not, either by way of writing a memo or coming up with a resolution that look, going forward, something like this, all the employers should enjoy XYZ. Other than that, that agreement per se, even though it's a commercial agreement, it's a commercial setting, the agreement is collective agreement is not binding until you integrate into it. So these are things that, of course, intermediate one are in between. So they're all a question of facts and circumstances, but just to let you know that they are all presumptions, and each of the presumptions are rebuttable. In law, there are two types of presumption. You have irrebuttable presumption, the one that cannot be denied, and you have rebuttable presumption, the one that you can bring further evidence, further facts to change the state of affairs. Right. So, of course, the fifth element is valid capacity. Is valid capacity. What is this? Yes. The last element of valid contract is contractual capacity. So here, it also have general rule and exceptions. General rule and exception. Of course, I believe there's no question on intention to create legal relationship. I believe there's no question on that. Are we still here?
Yes, sir, we're here, sir.
Yes, sir.
Well,
Yes, sir. Thank you, sir.
Yeah. Hello. So the here too, as I said, there's general rule and exception, which have to pay attention very well. Now, the general rule is that with capacity, the rule is that every person have the capacity here. Is the governor still in this class? The class governor in this class?
Yes, sir. I'm here, sir.
There's some noise at the background. I don't know what you are doing.
Yeah, I've muted them. I've muted them, sir.
Okay. So generally is that every person have the capacity to enter into a valid contract. But because contract has to do with some reasoning, some thinking, before you need to analyze what you're going into, know the consequences of breach of it before you take a decision whether to give your intention or not. So based on that, the law tried to develop some protection for some persons that are vulnerable, like illiterate infants, companies, and lunatics, mad people, things like that. So why we say that as general rule, every person, as I said before, a person in law is both human being and artificial being. So human beings are persons, but also companies by virtue of Section 43 of Companies and Land Matters Act. Company also enjoy, they have, be conferred with the, status of, they have powers of human beings or persons with full capacity, natural person with full capacity. So what a natural person with full capacity can do, the company can also do the same thing. If you want to buy, you can hire, you can employ, you can even, recently, even sue companies for committing rape. So if a company can be sued for, or company can be sued or fined for committing rape, then there's just nothing that a company, a law that you can't think that a company can do that you cannot do. You want to promote corruption, or steal money. Company are stealing money every day, left and right. So and then when I say person, it's both natural persons and artificial being, registered companies, for instance. So because these other persons are vulnerable, the law deems that local, they might not have the capacity to think through all that required. So the law now makes some requirement that must be gone through before a contract is binding on any of this category. First one is illiterate. Illiterate is someone that cannot read and write in the language of the contract. So if the language of the contract is in English language, and the parties or a party cannot read and write in English language, then that person is illiterate. If the contract is in Yoruba language, but the parties cannot read and write in Yoruba language, even though they are professor of English, that professor will still be illiterate. So the language of the contract is what determines whether someone is illiterate or not. So in Lagos State, for instance, and just like any other law, in Lagos State, there are obligations on someone that's writing on behalf of the illiterate, what the person must do before that contract is binding on the illiterate. And you can find that in Section 1 of the Illiterate Protection Law of Lagos State. Those requirements are there. Can someone read it out? Can someone read those three requirements to know you are following?
Number 1, write his name and address on the document.
Start from Section 1.
Section 1. Okay. Section 1 illustrates protection law, IPL of Lagos.
Illiterate protection. Illiterate.
Okay. Illiterate protection law, IPL of Lagos State, oblige a writer of any letter or document on behalf of an illiterate to comply with the following requirements.
Good.
First one, write his name and address on the document. Second, ensure that prior to the document being signed, it was read over explained in the language understood by the illiterate person, and states that he instructed to write the letter or document, and that the letter or document fully and correctly represents his instruction.
Exactly. So these are requirements of law. You can endorse that at the cover page. We can prepare a separate page and attach to the agreement. But you would have written down on behalf of the illiterate. You must put your name and address. If they want to verify or call you for interrogation, they can call you and ask you. You must also clearly write on it that look, before the illiterate sign on that agreement, you read it over and explain the language that the illiterate understood. And of course, that document represents what the illiterate instructed you to write, you know, and you know, if you represent the instruction of the, so if it's only when you do all of this that that document is binding on the illiterate. Then of course, even in Lagos, Ogun State also have similar stuff. You know, we are in Ogun State dealing with landed property. If you want to buy land from illiterates, remember that the language of law is Nigeria is language of law in Nigeria is English language. That's the language of law in Nigeria. So you see that if you go to Ogun State, for instance, people are buying land left and right. So those villagers might not know anything about English language. Now, if you buy any land from this illiterate in the villages, it's not binding on the illiterate. That means that they can deny you. They can deny you unless that agreement with those illiterates in the Ogun State, that agreement that you sign with them must be the presence of a magistrate, judge, or president of grade 1 or grade A or B customary court, or justice of peace. So these are all staff of the court, either president of grade A or grade B customary court. They are all, so it must be done. It's like you must go and that person illiterate must take the person before a magistrate court judge and sign a price of that money. If we don't do that, that agreement cannot be that's a good state for you. For infants, it varies, but for the purpose of contracts, you look at section 277 Child Right Act, is someone that is 18 years and above. At common law, it used to be 21 years, but now it's someone that has 18 years and above. So what I mean is that into also rules where the contract are binding on the infant and the areas that are not binding and what needs to be done. So, but the general rule is that if you go somewhere that you usually go for shopping, you want to buy some items, to go for shopping in a supermarket, and someone selling to you in that shop is less than 18 years, you have to be very careful. You want to buy building materials, the person selling those building materials to you is less than 18 years. You have to be very careful because it's not protecting you at that level at all. So the owner of the that's not the price for those things, just lay something on you. So be very careful when you are dealing with someone that is less than 18 years, because the law is saying that you don't have the capacity to enter into a valid contract. So you pay attention on that. Now, but for the purpose of infant contracts, there are some contracts that are, binding on the infants, and they call them contracts of necessaries. That's those contracts that are, are usually needed for the life of the infant are binding, like education, like training, like apprenticeship, even though the person is less than 18 years, it's still binding because they require that to grow. But where they are not necessaries, like loan, someone that is less than 18 years or giving that person loan, how to go and do what, Now, so all goods or services that are not, the child did not need his own life, are not. And one thing here is that what a child of a big man, a rich man would need is different from what the child of a poor person does. That is just the truth. So there are some things that may be necessary for in the life of, like someone that will give a demonstration in a case whereby bread and butter, or bread and butter and egg. Which of the family will eat? Just that among yourselves. Which of the families are likely to afford bread, butter, and egg? And then you have some families they can afford bread, they cannot afford egg and butter. You should know. I don't know, but you should know that yourself. So see that the one that you know that can afford only bread, cannot afford butter and egg. You are not supplying that one egg and butter. How do you want it to pay when the whole family put together? They cannot afford the egg and this thing. So it means that they're not binding. But when you go to that side, I can, you it will be necessary to buy even clothes that we wear. Supply of all the school there, a case whereby this guy was in Oxford University and the teller was supplying the goods, clothes to that child. When in fact the parents have made enough clothes for that child, go ahead and you know what is not binding on because already the family has already provided enough for that child. So you have to watch out to all of those things. So as I said before, contract and necessaries, things that without which individual cannot exist, they depend on it. Those ones are binding. Contract or beneficial services are also binding. Apprenticeship, employment and things like that. They're all, lessons, home lessons and all of those ones. If you employ, someone for your child, and you not pay, even when the child grow up, the person can sue and claim all those payments because there are things that are necessary for the life of the infant of the child. Now, for the company, a company, two documents are very important to the life of a company. One is what they call the memorandum of a company, and the other one is articles of a company. You should know this. You can Google it. The sample of it is online. You can always Google it and you can always see it. Now, for every company, the memorandum of association provide the rules that regulate relationship between the company and external persons. That is outsiders. Outsiders are people that are not shareholders, they are not employees of the company, they are not directors of the company, they are not, so they are just outsiders. They are not part of maybe the or
I can't understand.
So we can hear you, sir.
buy shares, potential people that maybe they have intention of buying shares in the company. You are here, but I'm hearing you now. Hello, hello.
Hello,
Yeah,
sir.
we can hear you now,
We
sir.
can hear you now.
No, sir.
So Jethro, your hand is up. Let me just conclude this one so that I can ask question now. Jethro, note your question down. Let me just finish here, so then we can ask questions. So, but you can hear me now?
Yes, sir, we can hear you.
So a company,
Yes, sir.
yes. So if you look at the memorandum of company, the articles has to do with internal dealings of the company, like between meetings of shareholders, meetings of directors, sharing of dividends, quorum, all of those things. These are things that you can find in the articles of a company. So in that memorandum, there's a clause that known as the object clause of the purpose for which the company is formed. Now that's where the capacity of a company is established. So all of you that are working, those of you that are working, you have to find out from your employers. You can, if you ask anyhow, they won't give you. But if you can ask in a careful way, they'll give you, and then you go to that in the memorandum. Usually, the first page also you see the object of the company. You see they will list many things there. So what I mean is that once the company is incorporated, they can only carry out businesses on those things that are listed under that. Anything outside that is amount to a company acting beyond its capacity, or what they call authorities, beyond powers, or what they call ultra virus. You know, if you want tomorrow on Monday when you go to office, go to your colleague when they are gathered and doing something, tell them that look, oh, what they are doing is ultra virus, and they leave that place before they ask you further questions. Just say it and disappear before they ask you those questions. Don't. But what we're saying, you know that within you, what we're saying is that look, oh, what they are doing is beyond powers. But you know, just say so that you start respecting you in the offices. That's all. So that you gain respect as you know. So you see, Section 43 says that look, a registered company will have the powers of a natural person with full capacity. So it means that they can do all the, but then that natural powers of full capacity is limited to the object for which is limited in the listed in the company. So you see, it's so harsh that look, once as businessmen, if you want to go into a contract with a company, if that company you are going in that contract with doesn't have the powers to do that, you are wasting your time. That's why you see that in every agreement involving a company, there will be a clause stating that the company hereby warrants that it has the powers to do or to enter into this agreement. You always see those. So if you see those kind of clauses in an agreement, this is why it is so. Because if a company doesn't have powers to do that, if they don't have the powers in the object clause to do that, they are wasting their time. That's why you see that Zenith Bank cannot involve in construction of railway. University of Lagos cannot involve in construction of building. Because University of Lagos, if you look at University of Lagos Act, it's all about education, education, education. Otherwise, right now, University of Lagos, they have engineers, they have civil engineers, they have building, department of building, the architecture are all in the University of Lagos. We can't see them building those things themselves. If they want to build, they'll go and bring external contractor because those contractors have the object to construct. UBA cannot involve in construction of bridge. That's why you never hear that they're giving UBA a contract to construct a bridge because the object clause of UBA did not allow them to go into those kind of contracts. Even the owner of UBA, Tony Lumo Landa, he has, you know, the wife is a medical doctor. They're going to build a very fantastic hospital in Surulere or so. You know, a different company, they didn't use UBA to go and build, say UBA is constructing hospitals. There's not in the object clause. Now, there's a particular case whereby, you know, this guy was working with a company, right? And because he needed a doctor, you know, they trained this guy, they train him abroad, so that when he come back, he will not working for them as a medical doctor. When the guy came back from abroad after training 7 years training using the company's money, he discovered that look, that company don't even have the powers to train them abroad. They use train a medical doctor and retain a medical doctor. So he came back abroad and resigned, and the company sued him. And the guy said, "No, what? For keeping me as a doctor and training me, it was authorized beyond your powers," and that was how it ended. If you are the one, what would you do with that young man? What will be your position? What will be your take? Hello?
Hi, sir.
I said, what will happen? What will you do with that young man now? You have trained someone abroad. He has come back and resigned and told that, look, oh, that training that you did for him is beyond your powers. What will you do?
I think as a, let's say as owner of the company,
Yes.
when sending such an employee for training, there should be a kind of document to be endorsed that, okay, well, after the training, you will serve us for so period, like that and like that. If that
They did.
is not,
They did that. So the guy was saying it's not binding on me. I can't obey that document. It's not binding because you don't have powers to even go in that line of business. I mean, that agreement in the first instance.
And nothing can be done. Hello, sir. Living for God.
Hello, sir.
Yes, yes.
I will
Yes.
file a case to retrieve his certificate. Since I do not have the capacity to send it for training, then you shouldn't have the capacity to hold the certificate and use it.
Well, I do. Okay. Oh. The guy has came certificate. He just came and resigned. He didn't say that. He just came. You know what? I resigned. I can't work with you again. Simple.
Then, sir, according to the law, what kind of disciplinary measure that
You are,
laws holds on such person?
you are a senior advocate of Nigeria. You are a senior advocate. I think you can also help.
So we demand the refund of the money expended for the training, sir.
There's no valid contract now. You know, it's void. When you don't have powers or do something, it's void. You can't demand this thing. Let me come back to it so that so that was the position. And this what I'm telling you now happened in the case of Continental Chemist and Ifikando. That's what Ifikando did to Continental Chemist. They trained him. He was just normal chemist like this, but they wanted a medical doctor.
That's not to send out to people. I told them that I'm the man. I'm the one that puts water. Are you? Oh,
All I do. So me, I'm teaching. People are making love. I mean, glory, what is going on there? Or no moon, what do you call it? Me, I'm teaching you are making love there with your husband, or what do you call it? That's not funny. Oh. If you're not ready to come to class, you don't come to class. Don't come and be showing us this. You are a lawyer. I will sue you for contempt. Yeah? I will employ Mary Jane. You'll be my lawyer here. If Glory do the same thing, we'll sue her on Monday. The case will appear on Friday.
Sir, we don't need to. Sir, we don't need to sue him. We just need to sentence him.
No, you have to give him fair hearing now. You tell us why. I'm struggling with the network. The little I could get my network, interrupting my network again. Huh? That's by the way. So what happened? This happened in the that's what they did. So as a chemist, they had a chemist, so they needed a medical doctor. You see that because they needed a medical doctor, they want now train their staff, fake handle, to go and become a doctor, so that when patients come, the doctor will examine them, and then they will they will get money from them from that examination, and then they also sell drugs to them, so that all the money will not be going outside. That was the intention. But the chemists did not have powers to employ to train a doctor and even have a doctor that operates under them. That was all that they did. And the Fikano just came back and resigned. All the fights that Condita chemists did, they didn't win the case. That was how the guy went away. Now, because you see that that is very harsh. And because of the harshness of that law, Kama 2020, the new Kama now has tried to reduce that effect of that harshness by saying that, look, and that's why you can have in the last three ones that you can have down here. So why in the past there's no remedy, now there's a remedy. So a company don't have powers to do anything outside the object clause, but the minority shareholders or debenture holders can apply to court to stop in action that is authorized. So Continental Chemist, for instance, no, any person, a creditor that maybe a bank which borrowed money to Continental Chemist would have stopped it from don't use our money that you have to go and train someone, or a shareholder can also do that. In addition, the Continental Chemist can also go to court and seek for compensation. Yes, now that you don't want to work with us, pay us these damages based on what we are spending on you. So this is what they would have asked. They just that this portion of this remedy were not available at the time that this case was decided, but now it's available. So at least now you can always claim the remedies. So that's all for today. The time is fast spent. If you have any question, please ask. If you don't have, then we'll end here. We have
Good
looked at
evening,
all the
sir.
elements of contract. Yes.
Good evening, sir.
Jetro,
So
go on.
I don't know. Yeah, okay. So I was listening when you were lecturing, and then you did mention that the element of collective agreement does not bind the employer with the union, and that it has to be transferred to the contract of employment or so before it can bind. So when I look at the collective agreement of my company right now, I see almost like the element of a contract, maybe the acceptance, the offer, and all of that present in a collective agreement that the union had with the management. So does that mean, and we've been implementing it, even though it's not stated, like we don't put it in their letter, but it's part of the agreement, and where, so does that mean, that cannot be enforced? Should maybe an employee, or should the management fail to fulfill that, and then can't the employee go to court and say, oh, no, this is the agreement, and the court will acknowledge that yes, you management sat and the union and they agree that this is what should be, these are the terms, and then they adjusted the terms of their, I just want to understand why the element that is lacking in the collective agreement that renders it, not enforceable or not acceptable as a contract.
Yeah, because that is because the point is that the contract of employment is individual, it's individualistic. So you don't have group employment. There's no, even though you are working in a company like you are 300 in their employment, didn't give you a group employment letter. Each person have individual contract with the company. So if you want to bring something, and it was you that accepted it that way. So if you want to bring something outside of it and impose on it, you need something else to be done. That's just that's the reason. You need to integrate it as part of it. Otherwise, it's not binding on the parties, because they will still go back and use the agreement that you signed with the company. What the union is bringing is not there. It's not part of it. That's just
Oh, okay, sir. Then the second question is, you make mention that when you go to a supermarket to buy something, and we should be careful so that we are not dealing, maybe because it's like a contract, that we're not dealing with under it. So I'm
yes.
now asking, should we now say, please show me your, how old are you before we buy or something? Or how do we know? Because some people grow, older than their age, and then you wouldn't know by, so how do we ascertain before we now make the contract?
There's what they call informed reasoning. It is, you are an adult. There's what they call informed reasoning. Because what happens is that by the time you are arguing this argument, they ask you, how old are you? You that is saying that, how old are you? So they will say that you're supposed to have known. That if you don't know, you would have asked. Otherwise, the child will just pack the whole shop and give you and collect 10 naira and keep. Simple. Because they don't know, they're happy that that mommy have sold for you. When they pack all the goods and give to one man for just 100 naira. Mommy have sold because they're happy that they sold the whole shop for 100 naira. They don't know all those things. That's why the law will not protect you. They will go after you. So that's why they say you are supposed to know. The law will start saying you are supposed to know. It becomes a big problem for you.
Oh, I understand, sir. Thank you.
Excuse me, sir.
Yes.
Excuse me, sir. On this, what about the adults that kept the kid there to mind the shop? Is there no repercussion to such action? Okay,
no, so that's why when because the issue is that when someone that has a shop, all this issue of agency and all of those things, even as contract of agency, even you say that the person is the principal is the one that put that child in that position, it's still the same thing. You that contract with that person, you should know that this person is underage. So your reasoning, because the law is presuming that look, you are imposing your reasoning on your own maturity on that child. That is the presumption. So they're not even looking at it from the side of that you are imposing. There's a possibility of you imposing that on the child. That's all.
Excuse me, sir. I have a question.
Go ahead, but this is also my time. I want to leave, but you can add this.
Okay.
Go on.
I actually dropped the question on the chat box, but you not respond to the question. Is on the area of the land purchase, and you were actually referring to Ogun State, but in the document on this slide is actually indicating Osun State. So I want you to clarify those specific requirements of the law. Is there a law of Osun State or Ogun State? That's my question, sir.
Sorry, I didn't hear your question completely. Can you recast the question?
The question is on the land issue that you were referring to Ogun State.
Oh, okay. Those yes, go on. What happened?
So I want to clarify. Are you referring to Ogun State or Osun State precisely? Because the document is actually indicating Osun State, not Ogun State.
Oh, Osun State. Okay, Osun State. Yeah. It's not document. It's law now. I'm talking about a law. So, what is it? What is it again? Yeah,
Mr.
Osun
Tyler,
State.
wearing this
Yeah,
t-shirt again.
Osun State. Osun State. Yeah,
Huh?
Noted, sir. Thank you, sir.
Osun State. Mm.
T-shirt is this is the third time you're wearing it.
Okay. In the absence of any other
It's the one
question,
that fits you.
class governor move motion for adjournment. The court will sit again the same time next week, Friday, by His grace.
Thank you, sir.
Okay. As the class
Thank you,
governor
sir.
move the motion, as we move the motion,
Yes, sir. Noted, sir.
okay.
Arise.
So arise. So the
Arise.
court adjourn. Okay, all
Arise.
right.
Arise.
Bye.
Adjourn next week.
Thank you,
Adjournment.
sir.
All right. Bye. Bye.
We adjourned today.